Hello, good afternoon, everyone, or good morning if you are not on the East Coast. My name is Anna Ricklin, and I work at the American Planning Association in our Planning and Community Health Center based in Washington, D.C. I'm so excited to be offering today our second session on planning law and health, on planning and zoning for public health, exploring legal issues in partnership with the Centers for Disease Control and Prevention and APA's Planning and Law Division. We have a great setup of panelists to speak to you today who have expertise on the history of planning and how we can think about planning law in today's world as it can impact public health. But first I want to have an introduction from our representative from the Planning and Law Division, Jenny Nolan.
Thanks so much, Anna, and hi, everyone. The Planning and Law Division is really thrilled to help host in this webinar series. One of the major elements in our whole mission is to really serve as a clearinghouse for important legal concepts and techniques developed at the intersection of planning and law, and to educate our members and others, get information out there regarding those ideas. And in this instance, an understanding of the legal basis of planning to promote and protect public health through land use is critical to implementation, to actually seeing on-the-ground change in our communities. So certainly we were really thrilled when Anna invited us to get involved. And I just wanted to say a few of the things about what we have going on that's related. In my day job at Pace University's Land Use Law Center, we've been working with a team of students on pulling the best practice examples together for comprehensive plan and zoning code provisions related to public health as part of building out the APA's New York Metro chapter, Planners for Health Toolkit. And the Planning and Law Division will be publishing an article on this research in our summer newsletter. So keep an eye out for that. And thank you so much for joining us, for being interested in this topic. I'm excited to hear the lessons that our speakers have to offer, as I'm sure all of you are. So with that, I will turn things back over to Anna to get us going. Thank you.
Thanks, Jenny. Yes, we are happy to have you here, and also want to note for everyone on the line that we are recording this webinar, and it is being offered for 1.5 credit AICP law credits. So I wanted to move on to the webinar itself, and Montrece McNeill Ransom from the Centers for Disease Control and Prevention is our moderator today. Welcome, Montrece. Montrece is the team lead at the Public Health Law and Training Workforce Development Office at the CDC, and I'll turn it now over to you, Montrece.
Thank you, Anna, and thank you everyone who has joined us this afternoon or this morning, of course, depending on what time zone you're in. As mentioned, my name is Montrece McNeill Ransom, and I serve as the team lead for Public Health Law Training and Workforce Development with CDC's Public Health Law Program, where our mission is to advance the use and understanding of law as a public health tool. Today's webinar is focused on land use planning and zoning for public health, and we're going to be really looking at the legal issues through 3 perspectives. This webinar is sponsored by the American Planning Association, Planning and Law Division, and moderated by CDC's Public Health Law Program. So this 90-minute session is really going to explore the connection between health and the built environment, highlight legal and ethical issues and considerations related to zoning, environmental justice, health disparities, and also provide some recent examples of community approaches to incorporate health goals into their comprehensive or sustainability plans. We are fortunate to have an excellent panel of speakers with us today, and after briefly introducing them, I'm going to turn the mic over to them, and we'll get started with the substance of our program. I'm going to introduce each speaker. They're going to provide their remarks, and then I will return to moderate the Q&A portion of the webinar. All right, so our first speaker is Kochtitzky. And Chris is a senior advisor in CDC's Physical Activity and Health Branch. Chris has held several CDC leadership roles, including Deputy Director of the Division of Human Development and Disability and Deputy Associate Director of the National Center for Environmental Health, Office of Planning, Evaluation, and Legislation. He's also served as coordinating lead for cross-agency work in healthy communities, healthy transportation, and healthy homes. Chris is also a member of the American Planning Association, the American Public Health Association, and the National Environmental Health Association. And over his career, his personal areas of research interest have included health policy analysis, public health law, and vulnerable subpopulations. Most recently, Chris's work has focused on analyzing the impacts of local community design and built environment choices on public health areas such as physical activity, environmental health, disability-related accessibility, aging in place, and injury prevention. Chris holds a Master's of Science in Urban and Regional Planning and is also an adjunct faculty at Emory's Rollins School of Public Health, my alma mater. Our second speaker is going to provide us the legal perspective, and that is Ms. Melinda Ramos. Melinda has been employed with the Fort Worth City Attorney's Office since 2002, and after serving as a prosecutor for 2 years, she moved into the transactional division, and since that time has really focused on giving advice to the City Council and has served as a primary legal advisor to the city's Planning and Development Department, and the Planning and Development Land Use Boards and Commissions, as well as serving as a legal advisor on natural gas drilling regulations and economic development issues. Ms. Ramos is the section chief of the Land Use and Regulatory Compliance Section, which is responsible for regulations governing the use of land in the city, use of grant funds from state and federal agencies, enforcement of code compliance, and also matters pertaining to the city's water and storm water utilities. Before joining the city, Ms. Ramos earned a BA in History from the University of Texas at Austin and her law degree at Texas Wesleyan University School of Law, and she received her license in 2001. Our third speaker is going to really sort of bring it all home for us today and provide a case study of how all of this comes together in a local initiative. Ms. Terri Harding, she serves as the principal planner for Metro and Community Planning in Eugene, Oregon, and holds a master's degree in community and regional planning from the University of Oregon. She's got a bachelor's degree in environmental studies from the University of California, Santa Barbara, and has worked for county, state, and city governments doing long-range planning for 14 years, in addition to 8 years of experience in land use consulting. Terri is currently leading the City of Eugene's urban growth boundary adoption process, which is a big step towards implementing the Envision Eugene community vision for managing the next 20 years of growth. And with that set of introductions, I will go ahead and pass the mic to Chris.
All right, can everybody hear me? Can everybody hear me?
Yes.
All right. Afternoon or good morning, as we've said. I'm Chris Kochtitzky, and I work in CDC's Physical Activity and Health Branch, and I'm going to try to kick us off by starting with some of the basic historical concepts that underpin both public health and land use and zoning law. And let's see. Sorry, I'm not. The slides are not advancing.
I can advance it.
Okay, then let's do that. Go to the next slide, please. Thank you. So as I said, the historical background, interestingly enough, for those who don't know, is very much overlapping. Urban planning and public health both started in the late 1800s and early 1900s, and the original Supreme Court case that validated land use law and zoning as a legal governmental power, Euclid, that many of us in planning are familiar with, actually cited an earlier case, Jacobson, that had to do with public health, and indicated that zoning at that time was a legal governmental power because it was designed to protect the public's health. At that time, as zoning was in its very infancy, people really believed in single-use zoning, because they were trying to keep the toxic tanneries away from the residential tenements. However, as our understanding through the 20th century has evolved, what we've begun to understand is that it's important to keep some uses away from each other, but the single-use zoning has some significant negative consequences. Next slide, please. So recently, the U.S. Community Preventive Services Task Force, that is a non-federal entity related to the Department of Health and Human Services, has examined the evidence base around specifically how built environment, land use, and transportation related decisions have an impact on physical activity, as a for instance. And so that panel is made up of non-federal, unpaid experts who advise us in the federal government and the rest of the world on what the strongest science base for some of our decisions are. Next slide, please. In this particular review, we identified over 61,000 papers that have been written in the last 15 to 20 years related to built environment and transportation interventions that may or may not affect physical activity. And out of that 1,000 plus papers, we identified almost 100 that were of the highest quality. And those 90 studies formed the basis of this particular recommendation from the task force. Next slide, please. Specifically, it makes a two-pronged recommendation. Basically, what the task force found was that if you just affect the transportation pathway, be that sidewalk, bike lane, or transit corridor, it won't necessarily provoke people to be more physically active. But on the other hand, if you just address the land use, the activities along the pathway, they may increase the use of those activities, but people will mostly drive to them. So the recommendation is based on a set of activities from either of those two sides, the pathway side and the land use and environmental design element side. So within those, they're very much related to, in both cases, things like land use law and zoning, policy elements related to complete streets policies and active design codes on the one hand, and mixed-use zoning and residential density on the other. Next slide, please. So I'm going to very quickly go through the specific elements that were identified in the science review. On the one side, things in the codes and design world that relate to street design and connectivity, pedestrian infrastructure like sidewalks and traffic calming, bicycle infrastructure like protected bike lanes and street lighting, and public transit infrastructure and accessibility on the one hand. Next slide, please. Combined with at least some activities on the land use and environmental design side, such as mixed land use, giving people things to do along the improved pathway, residential density to ensure that there's enough people along the improved pathway, proximity to community or neighborhood destinations like banks, grocery stores and health facilities, as well as parks and recreational facility access, again, to give people things to do along the pathway. Next slide, please. The reason I went through quickly that is that so many, operationalizing so many of those elements of that recommendation involve the activities of many people on the phone today and the subject matter of this particular webinar. Master planning, zoning and land use law, complete streets policies, the policies that go along with safe routes to school, school siting, if the schools aren't close enough to where the kids live, there's no way they're going to walk or bike, active street and building design guides, and of course economic development incentives. Next slide, please. Quickly, what I want to do for the rest of my time is to go through a little bit of what has been done out there by way of creating research translation as well as best practices, and highlighting a few success stories. So in the area of master planning, you can see that APA has taken a lead in defining what are best practices for comprehensive planning. They've identified comp plans such as the Temple Terrace plan that is very much focused on active living, some of the best quality planning out there. And we also have partner organizations like Change Lab Solutions that have created model comp plan language related to complete streets. And these kinds of policy interventions can include things like multimodal districts, mobility fee exemptions to pay for traffic calming and bicycle facilities, and to ensure that there's pedestrian, bicycle, and transit connectivity and mixed use and mixed income districts. All of those things are critical to people being safe and active in their daily lives. Next slide, please. In the area of land use law and zoning more specifically, there are a number of groups out there who are either doing research, such as my colleague Jamie Shariki at University of Illinois at Chicago, looking at what are the elements of active living oriented zoning that can support physical activity. And as the researchers define some of those critical elements, again, the partners, both like Change Lab that did the Move This Way guideline that you can see at the top, as well as the Metropolitan Planning Organization in Chicago, CMAP, that created partnered with a number of people to create the FormBased Codes guide that you can see at the bottom. All those things are designed to support zoning code decisions, subdivision code decisions, and in some cases, and I apologize for the way the slide has kind of run off the bottom there, unified development codes that cover zoning, subdivision, and even building codes all in one, that those follow the best practices that support safe and active living in our communities. Next slide, please. I wanted to cover FormBased Code. That many of you may be aware of this, but as opposed to the traditional Euclidean zoning code that is very much separation of uses, this encourages mixed uses as long as there aren't any dangerous ones. It encourages mixes of housing types, and it tailors the zoning requirements to the specific places and the individual residents of those places, their needs, creating a sense of place that's driven by local residents, business owners, and such is absolutely critical to creating the communities that are safe and active and accessible. Next slide. This is just a quick example of one particular sheet in a form-based code, and one of the things I wanted to point out is that it's considered by some people to be a stronger version of code because it mixes text with tables and graphics to drive home the specific design elements that the local residents and business owners have collaborated on trying to create the community that they want. Next slide, please. And this shows how what's called context-sensitive design operationalizes that form-based code. You have different contexts and different zones and districts that go from very rural to urban to a different type of urban commercial district. And within each of those zones or districts, you have a particular kind of zoning code that supports those activities. Next slide, please. Again, sort of to flesh out the context sensitivity, it defines the kind of activities and the design criteria that will support those activities. It's a mixture of building and street design, Again, it tries to serve the needs of all users, be they automobile, bicycle, or pedestrian, for instance. Next slide. Moving on to complete streets policies, those are only really successful if they are merged with land use and zoning policies that are supportive of all users and that create the complete streets. For those who aren't familiar with the term complete streets, those are at its highest level just streets and streetscapes, sidewalks included, that support the safety and the accessibility for all users, be they on foot, on bike, transit user, or automobile user. And again, the way these policies have to integrate with other land use and zoning policies are that they lay out exactly how both the zoning and land use policies need to operate, as well as the design, operation, construction, and maintenance of the streets. They try to move the design and maintenance of the streets as the local users define what they want, shifting the status quo from the fairly auto-dependent communities that we have created to one that's a more of mixed users. And they tend to try to seek more equitable allocation of resources as well. And you can see that there are a list of best complete streets policies that's published each year, and guides to building healthy streets that again have been created by colleagues at the Change Lab Solutions Group. Next slide, please. Specifically, and a lot of this may seem like it's all local activities, but there are a number of states that have gotten involved to try to support these activities, and one of them is North Carolina, that's created a complete streets planning and design guideline. And you can see here that in this guide, and the link to the guide, which is available to everybody, is at the bottom. You can see that they lay out both in pictures and words and descriptions everything from dense central business districts all the way to rural villages and countrysides. And next slide, please. They also, in the same guide, they lay out how different users and uses can interact safely and smoothly and harmoniously, whether you're talking about an urban or suburban main street or a rural village main street. Again, this is how the code can really, both graphically and in terms of legal text, can be a facilitator or a barrier. Next slide, please. Safe routes to school policies are absolutely critical, and again are dependent on how land use and zoning operates in the area. The reason I think that they're so critical is that children are a potentially vulnerable population because they don't necessarily have the instincts or the experience that adults do, but also we form our habits and our expectations early in life. And if the generation of kids who are growing up today grow up expecting to have a very physically active, community-engaged life, I think they'll carry that into adulthood, and the policy and legal decisions and structures that we put in place will either support that or be a barrier. And again, we have partners at the Safe Routes to School National Partnership, at Change Lab Solutions, and other places that have created guides and models to support decisions throughout the country. Next slide, please. Finally, there is a mixture of active design guidelines that focus on, whoops, back one please. That focus on the interaction between buildings and building choices and the larger streetscape. This is New York guidelines that there's a whole set of supporting documentation that go with their active design guidelines, but it actually lays out how the buildings, the land uses, and the streets interact to support safe and active transportation, from making stairs more visible to planning and constructing buildings and streets with a wide variety of uses so that people have reasons to be out and being physically active. Always, as we promote more physical activity, we want to keep in mind that we want to do it safely. And so there is also a design supplement that deals with the interactions of the uses and how to keep pedestrians and bicyclists of all ages and levels of mobility and experience safe while they're being active. Next slide, please. Finally, economic development. Some of you may get involved in this because with economic development there are often contractual responsibilities, but there's a huge amount of money that's out there in the community development world that has begun to get into what we call the zip code improving business. And a number of the community developers have begun working through the Federal Reserve banks and others to engage both the public health sector and the hospital and healthcare sector to try to make sure that as they do development or redevelopment, that they do it in a way that it promotes and protects public health. Next slide. So these are some of the resources that are out there as you all begin to think about what you may want to do or change or do differently. The main purpose of what I hope that I've carried across is that there's very little that needs to be invented from scratch. There's a huge set of groups and activities that have already blazed a trail to some degree, and groups like Change Lab, the Public Health Law Center, and the National Complete Streets Coalition have developed both guidelines and models so that if you're in a mode of wanting to not necessarily invent something new, there's plenty out there to base your first dive into these areas. I think that is the end of my slides. So I will turn it over to our next presenter.
Good afternoon, everyone. My name is Melinda Ramos, and I'm a assistant city attorney for the city of Fort Worth, and I practice in land use, as Montrece gave you my intro before. So what I'd like to do is to go over with everyone the legal issues in planning and zoning for health. So kind of we start at the beginning, and so the beginning is, what is our legal authority as municipalities or other governing bodies to adopt regulations? And so the regulatory authority comes from our police power, the power to adopt regulations in the interest of the public's health, safety, welfare, and morals. And that regulatory authority is largely delegated to municipalities, or it's delegated through the local level. In Texas, we are a kind of a home rule state, so long as your population is above 5,000 and you've adopted a charter rule, you kind of have a lot of ability to regulate, except where, of course, you interact or come into the regulations with the conflict with the state and or the federal government. What I've experienced, particularly here in Texas, that impacts this is increasingly local authority is being attacked at the state legislative level. In Texas, in our most recent legislative session that just ended in May, and a current special session that'll begin in July, bills are introduced and will be introduced that will limit the local authority of Texas to enforce tree preservation ordinances, which certainly have been used and do bolster public health, and strengthening vesting for property owners. So who are the players in this process? The players are lawyers, both those that work for governing bodies and those that work for property owners or developers. Certainly the planning staff or consultants that work for governing bodies, and then of course your local elected and appointed officials And lastly, most importantly, that have a tremendous impact on whether or not your policies that you want to promote, move forward, are the citizens and the stakeholders. So all of the neighborhood associations, all of the neighbors, all of the business community that would be affected by any regulations that you're seeking to put into place. So some of the common legal issues are, as we stated before, does the city have the authority to regulate? Certainly public health falls within the traditional framework for cities to regulate, so there's kind of not that much of an issue there if you get past that first hurdle. The second is what is the city's rational basis for regulating either this business, this outcome that you want to have, or the particular industry that you're perhaps wanting to add some additional regulations for, or if you don't, add regulations. So the primary issue that comes up is the takings issue. Does the proposed regulation take somebody's property interest in a compensable manner? There are three primary ways that that can happen. And the first is through a regulatory taking, where the regulation that you adopt is to such effect on a person's property that it affects their ability to either adequately develop or do what they want to do with that property. If it reaches a certain tipping point, it can effectuate a take, and you do have to compensate that owner for that regulatory take. The second is physical takings claims that occur, and most typically those occur if you adopt something like a complete streets policy, where as part of that initiative you do need to go acquire, let's say, sidewalk easements because you want to promote walkability in your community. You may have to go and acquire property, and you may have to actually perhaps condemn that property. The last one is exactions, and those typically occur when new development is coming in and you're assessing the infrastructure that would be needed for that particular development and you're requiring a dedication. So if an exaction is occurring, the main question that needs to be asked is actually a two-point question. Is there a rational nexus between the requirement that you're making and the public purpose, and is the requirement roughly proportional to the impact that that development is going to be making? So the other kind of issues that are more kind of procedural, but they still need to be thought about when enacting planning regulations are, does the city adequately follow the substantive and procedural due process? So you need to make sure that there's public involvement and participation, that there's proper notice and hearings, and for most states, if not all, open meetings will apply certainly for your land use boards or other bodies for your municipality that will make decisions on to the city council or the city council itself on whether or not these should be adopted. Does the regulation as drafted, applied, treat everyone the same? There's civil rights issues that you need to be cognizant of, and most importantly, you need to establish a legislative record, and that is primarily if your regulation that or policy that you adopt gets challenged. You want to be able to show that you have clear recitals that support the public interest and or the public purpose, that you have a citation of all of the public notice and the stakeholder input in meetings that occurred to support your legislation, and that you remember to always include the citation of the benefits to the public. The last thing that will come into play is the enforceability. Is the regulation that you're wanting to enforce, are there going to be issues with enforceability? How do you expect it to enforce? Is it going to be something that is proactive on the city's part to go out and enforce, or is this going to be the type of regulation where it's really going to be driven on a complaint basis? So there are, of course, other legal obstacles and other to implementation. Oops, sorry about that. So the first is vested rights, and that's where projects may vest for a number of years, making the implementation of the changes promoting the public health more of a long-term goal. There's grandfathering of existing uses, which can be eliminated eventually through abandonment, termination, or the amortization of. The rough proportionality, so the exactions and takings issues, and preemption through federal and state. The other obstacles to implementation, which aren't necessarily legal issues, but certainly have to be worked through as you're going through the process, are kind of related to NIMBYism, and so that, of course, is you may encounter where you have some traditional zoning going on and you're wanting to make a change to either form-based codes or mixed use. The resistance to the mixing of uses or densities, where it's been kept separate for a number of years, and so people may be a little bit hesitant and fearful of that type of mixing of uses. The second one really is kind of when you're going through and you're promoting a complete streets program, or you want to adopt a safe routes to schools where it may require the acquisition of right-of-way or sidewalks in order to complete those goals, is really thinking about the land acquisition and the budgetary constraints. So where the city is the driving force for the changes to promote public health through walkability measures, the acquisition may be more complicated or expensive than originally envisioned by the staff. And so usually these are budgetary concerns, but they may morph themselves into becoming legal concerns if condemnation becomes necessary. So the first kind of big issue, and hopefully this is not quite so onerous in other states as it is in Texas itself, but is vested rights. So vested rights developed from the 14th Amendment of the U.S. Constitution to prohibit the illegal takings of an individual's property without just compensation. And the purpose of the doctrine is to protect property owners from changes in municipal regulations when they have received a valid building permit, completed substantial construction, they've made substantial expenditures in reliance of the permit, or as in here in Texas, they've given the governmental entity fair notice of the project, and the quotes are deliberate there. So in Texas, the vested rights statute is heavily weighted to the developer to provide that fair notice of a project, and it ensures the developer is able to develop his project under the municipal regulations and policies. So the subdivision ordinance, the stormwater policy that was in place at the time that they filed their application, and it continues through the life of the project if certain progress is provided. So generally here in Texas, there are exceptions to the vesting, which include the building and the fire codes, which definitely involve public health, and certainly the construction specifications or methods of how to build infrastructure and regulations affecting imminent destruction of property. The net effect of vesting really is that the public health initiatives that are newly adopted, that are infrastructure related, or regulatory related, may be delayed for those projects where vesting is applicable. So the second kind of major one that we typically encounter here in Fort Worth is grandfathering, and so it's, you know, the legal non-conforming uses for the most part, but it really does also apply to structures, to lots, to features of developments, or signs that were legal when they were either created or built, but once the change has been made, they no longer meet the requirements of city ordinances. Legal non-conforming uses are supposed to go away someday, but very often they do not. They become perpetual and may, in fact, become part of the landscape. There are certain ways to eliminate the non-conformity. Those are through amortization, and that requires the valuation of the asset. You have to adhere to due process. That part of that due process is going to be a discussion with normally boards of adjustments, typically hear those, and it's figuring out what the monetary value of that asset is and how long it would take the property owner to realize the value of that asset back. The second primary way is abandonment, so it's the discontinued use for a set period of time. It can be as little as 6 months and as great as 2 years, as it is here in Texas. You can allow the transfer of use to a more compatible non-conforming use, and I have seen this in form-based codes where the more compatible non-conforming use is still better and may, in fact, as perhaps the code gets amended as it moves forward and people become more comfortable with the form-based code, become a conforming use. the last way to get rid of or eliminate a nonconformity is if the structure is destroyed by 50% or more, and that percentage is dependent upon a particular city. Here in Fort Worth, it's about 75% destruction. The other way that can increasingly affect whether or not you can adopt or implement ordinances that are related to public health is through preemption. And so although a city's police power is broad, it's not absolute, and it can't conflict with the state's general laws. If a conflict, or federal laws, if a conflict exists between a local ordinance, state, or federal law, if the ordinance duplicates or contradicts or enters in an area that's already regulated by either of those two entities, it can be either expressly preempted from the field or legislatively preempted from the field. And kind of areas in particular, I think across the nation and certainly in Texas, where we've seen state preemption and to some extent federal preemption is kind of in the location and the siting of cell towers, the location and siting of gas wells or regulating fracking, the ability to regulate where concrete crushing plants go can be an issue, particularly here. So it affects your ability to be able to, if you're able to, pass regulations that are related to air quality. So rough proportionality, as I stated before, typically comes through when somebody is either platting a piece of property or getting a building permit where, and it's usually for new development, so it occurs when a city allows the property owner to develop if the property owner agrees to dedicate a portion of the land for a public purpose or make on or off-site improvements addressing the public needs. So kind of like for complete streets could be an example given the topic that we're discussing today for public health. There has to be a nexus between the dedication, the exaction, and the public purpose, and it has to be roughly proportional between the impact of the development and the exaction that's being required. So it very well may impact the dedication or construction to support the complete streets policy. Wouldn't be able to require a developer coming in to build out the entire street. They're only responsible for their rough proportionate share of that street. And so, which is speaks to the second bullet where you require sidewalk dedication and or construction. And rough proportionality really arose out of what are the two seminal cases, and one is the Nolan case, where land use regulation doesn't constitute a taking if it substantially advances legitimate state interest and it doesn't deny an owner economically viable use of his land. There has to be a nexus between what's being exacted and the public purpose. And this was furthered by the Supreme Court in Dolan, where the court extended the essential nexus test to require rough proportionality between the development impacts and the conditions on development. The court did say in that decision that there didn't have to be a precise mathematical calculation. However, in many states, certainly in Texas, they've made this rough proportional analysis statutory and require an engineer to make that calculation. And it, just by extension of that, tends to be a mathematical calculation that occurs. What I wanted to do is try to show how all of these kind of interplayed, in particular with the city of Fort Worth and how Fort Worth wanted to advance public health objectives. So that's certainly been the goal for the last 5 years or so for the city of Fort Worth. So the three primary things that the city wanted to do was to develop walkable urban neighborhoods such as mixed-use growth centers, transit-oriented developments, urban villages, which encourage residents and visitors to get out and walk and bike and use transit for their everyday life, home, work, school, and going to other locations. There's been a big push to increase the miles of bikeways in the city, jumping up in 2016 from 104 to 150, and to use zoning and other city ordinances to increase access to fresh fruits and vegetables, and to promote farmers markets, to encourage healthy eating. So part of how the city has kind of tackled this issue is through a number of plans and other plans that our planning and development department and other work on that kind of speak to what Chris spoke about in his presentation. So we have a comprehensive plan that is supposed to lay out the vision for the city over a long period of time, anywhere from 10 to 20 years. It's required in Texas to adopt that by the state. But inclusive within it is inclusion of our master thoroughfare plan, in which we've adopted the complete streets policy. We include bike trails and pedestrian plans in there. We've included connectivity requirements in our subdivision ordinance, fresh market mobile vendors, economic incentives to encourage people to develop in such a way that it promotes public health for the community. And so just kind of depicted for you all is just kind of specific plans that the city of Fort Worth has adopted and incorporated into our everyday strategies of how to promote public health in Fort Worth. So kind of just three short little case studies is, one is our Bike Fort Worth plan. And so as part of and in support of that, we passed a bicycle parking ordinance that would require bike racks to be installed in commercial areas and other areas in order to promote people to bike. So of course the legal issue that arises with that, because we did that through our zoning ordinance, is that it really helps new and change of use development. So it's a long-term kind of thing to make sure that it goes happening. The other thing that we did was we passed a safe passing ordinance to encourage people to not be afraid to get out on the road, and also we included striping of bike paths so drivers would know where they're supposed to be, and bicyclists would know where they were supposed to be. And part of how we did that is we included bicycle lanes into our complete streets, and so as part of our dedication requirements, it includes enough of the right-of-way to include the bike plan. So part of that, as I discussed before, is the rough proportionality issue. It's been successful in that so far we've increased our bike lanes by over 400%. If I can get, thank you. So the next slide to come, how we try to improve or promote public health is through a master thoroughfare plan update. And the goals for that update were to build complete and context-sensitive roadways, to increase the connectivity by reducing traffic volumes, reduce emergency response times, and increase mobility. And collectively, all of those do promote public health, to get people out to be able to walk to the school that you see depicted on there. So the legal issues in place for that were vesting for projects that were kind of already in place. For those particular projects, there's nothing that the city can really do to have them adhere to it. You can make the process more attractive to them, and the developer will perhaps choose voluntarily to change their plans to incorporate more of that, because it makes their project actually more desirable. And the other issue as applied is the rough proportionality as it applies to the exactions to support the plan. Oops. I got one more slide and then we'll be done. So the last way we did it, as an example, is through zoning. So we adopted urban agricultural and fresh market mobile vendors. So the goal there was to reduce barriers for small farmers or fruit producers to grow on land that is available and bring their products to market. They were prohibited from doing so in single-family areas where we had just kind of, through the years, had limited the other uses that could go on to just single-family use, and so we had precluded that out. We made a change to add that in, and to provide support and promotion for mobile markets and carts. And you know, part of that was to increase access to healthy produce in areas where grocery stores or other areas where to buy that is limited. So those areas of your community where you may have food deserts. So the legal issue for that is to remove the restraints where the uses can occur and the requirements to regulate, to make it easier to encourage entrepreneurs, people that are like-minded like that, to take that opportunity and go into the community and create those that availability for fresh produce and in farming. So that is all I have for you all, and I appreciate everyone's time and listening to me this. Thank you.
Thank you, Melinda. And up next, we will hear from Terri Harding.
Great, thank you. I'm trying to advance here. Let's go to the next slide. Great. So again, I'm Terri Harding. I'm a principal planner with the City of Eugene, Oregon, and have been working in long-range planning for most of my career. Next. I'm going to talk to you today about the goals of our long-range planning project called Envision Eugene. Talk about planning for industrial development near existing neighborhoods in West Eugene as a case study, and then offer some thoughts on lessons for addressing environmental justice in city land use planning and zoning. Next. So first, a little bit about Oregon. In our state, every city must have an urban growth boundary with a 20-year supply of land and a comprehensive plan. The statewide program was established back in 1973, and it really had a focus on farmland, protecting farmland for the good of the economy of the state. There was less focus on planning in cities, but over the years, the 19 goals have been clarified through a lot of case law. And although public health is not one of the 19 goals, it is in fact tied to many of them, from housing to transportation to air and water quality and natural resources. Next. For Eugene's plan to accommodate growth, we started the project by responding to a state mandate. It was actually a House bill in our legislature that required the City of Eugene to establish our own urban growth boundary separate from the City of Springfield. We had shared a regional urban growth boundary separate previously. And that new urban growth boundary would need to have room. Sorry, we're still back on that one. For 20 years of projected population and job growth, which in our city is about 34,000 people over the next 20 years and 37,000 additional jobs. But in addition to fulfilling this state mandate, our project embraced this opportunity to discover a community vision about how we would grow. And we launched an extensive public process to complete the visioning and try to build community support for our collective values and outcomes of this planning process. Next. So we talked a lot about best outcomes during the visioning phase. We used a large group of people called the Community Resource Group, as well as targeted outreach and listening sessions with various stakeholders to develop these outcome statements that described people's visions of Eugene for the future. People used words such as access to opportunity, to employment, to housing and public services, transportation options, and education. The overarching theme that emerged was a goal to make Eugene more livable for everyone. Next. The community vision map that came out of this project depicts 2 growth management strategies. And I know this is a busy map, but you can see some highlighted in yellow corridors in Eugene. And our first growth management strategy is to focus growth and redevelopment along those key corridors, which are connecting our regional bus rapid transit system. And they radiate out from the downtown core. The second strategy is the concept of 20-minute neighborhoods, where people all across the city, no matter what neighborhood they live in, our goal is that they have access to shopping, transit, parks, and schools within a 20-minute walk of their home. Next. We received direction from our City Council in 2012 to start studying this issue of environmental justice. And what led up to that was a lot of community organizing by a local group called Beyond Toxics. And they teamed up with a neighborhood organization called the Active Bethel Citizens. They sponsored an environmental justice bus tour showing the community where the concentrations of industrial uses were in the western part of Eugene. And then this group lobbied the city council to include this direction to staff shown on your screen. This was the first time that the term environmental justice entered the planning lexicon in Eugene. Go ahead. And yes, thank you. The red oval that just popped up is showing the proposed expansion area that we call the Clear Lake Road expansion area, where the city was considering adding land for jobs, parks, schools, and at the time, residences shown in the light yellow. But through these environmental justice community discussions, it was determined that adding more homes in this part of the city near the airport and existing industrial areas would not serve the community's best outcomes. So this was dropped from the consideration pretty early in the process. Next. So as planners, we were faced with this basic question of what is environmental justice? And to learn, we turned to the EPA, and if you'll flip one more slide forward, a picture will pop up. We studied the issue and the definition of environmental justice provided by the EPA, and we hired an intern, Lucky, who was studying environmental justice for her master's degree and had worked with Beyond Toxics on this issue. So thanks to LinkedIn, I reconnected with Lucky just recently and found this picture. Go ahead. Our research included information from an equity and opportunity assessment, which was funded by a HUD Sustainable Communities grant. There's a map shown on the right side of this slide, which is a composite map of vulnerable populations in the area. We used community surveys about health and exposure done by Beyond Toxics. We used EPA and local agency information, and our local agency is called the Lane Regional Air Protection Agency, which is unique in Oregon, and examples from other cities, chiefly Portland and cities in California. We could not find any examples of environmental justice protections in land use code that we could find. Go ahead. Eugene also has a Toxics Right to Know program that requires industrial businesses of a certain size to report their use of chemicals and emissions to the city, but only within the city limits. And you can see on the map, the green ovals show the reporting businesses and where they're located in relation to our study area. And the red oval is a gap. Most of that area is outside the city limits, and there are several large industrial uses located in that area. Go ahead. A series of consultations were held with groups from the county public health department to the local air quality agency, a bunch of city departments and programs, commissions and boards. Eugene has a human rights commission, which is rare for a city our size, and local community groups such as Grupo Latino and Beyond Toxics, as well as neighborhood organizations. The results of the consultations and the research were summarized in a briefing paper on environmental justice, which we put on our website, and then resulted, stay on this slide, in a general recommendation that we plan for jobs that benefit the environmental health, economic, and social sustainability of the surrounding community, and that we plan to achieve that through plan designations that transition in intensity from the neighborhood to more typical industrial development. We also recommended looking at a new overlay zone with performance standards, using non-regulatory tools such as health impact assessments and good neighbor agreements, which there are a lot of examples of. And then lastly, partnering with those agencies I listed before, the businesses in the area, and the local nonprofits. Go ahead. The resulting map here is our proposal for the Clear Lake expansion area. It's a land use map. So in the southern part, kind of off the slide, is the existing Bethel neighborhood. And closest to those neighbors are a new park that's over 200 acres in size and a site for a new school for their school district. And then the closest industrial land is limited to campus industry, which is more like an office park type of environment. And then north, shown in the pink color, is our standard light medium industrial zoning, which matches what's already in existence in the area, but is limited by an overlay zone that I'll talk about next. So what we ended up proposing was a series of special standards within an overlay zone. And there is an environmental justice to these, focus to these regulations. They require interagency coordination, that's a staff role. Neighborhood coordination, that's a requirement of development applicants. There are a series of performance standards that are triggered either at land use permit or building permit. And then the nuisance standards are enforced by city personnel within the Planning and Development Department. So, for example, we have emissions standards not noticeable at the property line, and noise and vibration standards that would be enforced upon complaint by city staff. The prohibited uses in the overlay include things such as trucking terminals, which have a lot of particulates associated with them, wood preservation. So Eugene's economy is traditionally based on wood products manufacturing. And so this topic got a lot of conversation because there are several industries that do cause impacts in the wood products industry, and technology has evolved to a point where some were saying we don't need any additional regulations, and others were saying, no, we really do. This is our chance to put something in place that will protect for the long term. And so that is still under discussion. And then lastly, concrete and other really impactful manufacturing uses are prohibited. You can adjust some of the standards within this overlay if you still meet the overall goals of the zone, which are rooted in the triple bottom line of sustainability, which is a lens that the City of Eugene uses for a lot of policy decisions. If you're interested in looking at the Clear Lake Overlay Zone, the code is online, but it's not yet adopted. You can go to our website and take a look. Our last local public hearing is tonight, so stay tuned. I do not anticipate a lot of challenges to this part of the code. There's a lot of other things involved in establishing our urban growth boundary that are more interesting to people. Go ahead. Lastly, I've got some lessons learned from this project that I thought I would share with you, and you can go ahead. The first is that we spent a lot of time on the front end of planning, investing in talking to people, and that it really does take a lot of time for folks in the community to build that trust about where you want to go. This is a picture of part of the community resource group that spent a number of days together working out what are our best outcomes and what are our community values. Go ahead. Another lesson is to loop back with the underrepresented groups and the City Council. So since we had been given specific direction by our City Council to do outreach and address environmental justice issues, they were very interested in learning what we heard from folks in the community. So we attended events, we did targeted outreach bilingually at various existing groups and places around the community, and then we brought that results of that back to the City Council, which was very much appreciated. Go ahead. Our third lesson is to proactively communicate to fill the radio silence. So this I can't emphasize strongly enough. If you're not proactively communicating about your project, people make assumptions and fill in the gaps to that question your motives or what's going on with the project. So we were very much interested in e-newsletters, videos, updates to social media and on our website, in addition to going around the community and trying to meet people at events that were already happening. As our city manager likes to say, I want everybody to be sick of hearing about Envision Eugene because they've just heard about it so much. So we'll find out tonight, depending on how many folks show up at the hearing. And one more lesson I did mention our city manager. Also, throughout the process, we had a very supportive mayor and city council that were really invested in the 7 pillars, we call them, of Envision Eugene and in reaching the community's best outcomes. And that has been just a gold mine for city staff who've been working on this project for a number of years. So I know not everyone is lucky enough to have this, but for us, it was pretty critical to get us where we are today. And I think that's my last slide.
Well, thank you for that, Terri, and thank you to Chris and to Melinda and to you, Terri, for your presentations today. I know that I learned a lot, and it looks like our participants were equally engaged given the questions that we have received in the chat box. So I'd like to start with this first question. And this one's for you, Terri, and it's a question that seems to be focused on economics, and it's, how did Eugene go about balancing job development and industrial growth within environmental and social goals? I know you mentioned the mayor was and the city council were supportive, but what about the Chamber of Commerce or property owners?
That's a great question. So we had very active support from the Chamber of Commerce from the beginning, but their goals are a little bit different than environmental justice, as you might imagine. So the expansion area that we were planning for, I focused my presentation on the environmental justice aspects of it, but the other really critical piece of it was around job development and planning for the land that Eugene is proposing to bring in for the kinds of jobs we're expecting. So economic development, one of the main focuses of the project, just not the focus of my presentation today.
Okay, thank you for that, Terri. Let's give the next question here. I think this one is probably most appropriate for Melinda. And this one is, in considering planning or from a planning perspective, for communities wanting to begin to incorporate promoting public health, what should be the first way to address it from your perspective? What should be the first step there? Is it starting with infrastructure or land use, or is there another approach that they should be taking? Do you have thoughts on that?
I think based on my experiences here with the city, probably I would start with infrastructure, because I think it hits kind of a number of areas. You can add, as part of your Complete Streets program or adoption of the Complete Streets program, it's going to include bike lanes. It's going to include sidewalks, so you're kind of hitting at getting people out and getting people mobile, other than a car, getting people out and getting people walking into the community. And you're kind of building that infrastructure then that I think lends itself to then adopting zoning changes, or it sometimes happens hand in hand with the form-based codes and the mixed use codes to kind of get that ball rolling. But I think the infrastructure piece is the most important. The sooner that you can get that started, the sooner or lesser that vesting can apply and projects can move forward that don't have to comply with those new requirements. So I think infrastructure, at least for me, is kind of the first place to start.
Okay, thank you, Melinda. I think that answers that question well. I've got a question here that I'm going to direct this one toward to you again, Melinda. Mm-hmm. Actually, I'll direct it to all of our speakers and see what their thoughts are. At the macro level, what impact do you think that the change in the administration might bring to moving planning-related health initiatives forward, if any? Do any of our speakers have thoughts on that?
I'm very kind of curious to see how this goes. I know there's been in the news emphasis from the administration talking about increased spending on infrastructure, but it seems to me that is probably primarily focused on perhaps road building, which doesn't then kind of address the public health portion of it, to get people out of their cars, to improve the air quality, because people are out there either biking or walking or promoting mass transit, and maybe that will be a portion of it. So I think it's kind of an open question for me as to what this administration will do with that as part of their push toward more infrastructure type of planning for that.
Thank you for that. Chris or Terri, do you guys have any thoughts on that?
I don't have a lot to add.
Okay, all right, that's perfectly fine. I think, Chris, this next question is definitely for you. This is really focused specifically on the task force recommendations. There's a note that they're clearly important, and the community's used them before, this particular community, but they include a lot. So how should they choose which activities to combine?
That's an excellent question, and my answer may or may not please people. My experience is that the local experts in public health, in transportation, planning, and land use law have the local knowledge to take the larger scale science and decide how to apply it. The reason that we ended up with the two tables was because what the research showed us was that many different combinations of pathway improvements and land use and activity additions and modifications could result in greater physical activity. So I think the most important and impactful thing somebody at a local or regional level can do is reach across the aisle. If you are a planner or transportation person, go find the public health director, and if you're a public health director or a public health staffer, go find your counterparts in planning, transportation, and public works, and share your knowledge and expertise, and then make a decision from the menu. Sort of, you guys are the best positioned to decide what to pick from the left side of the menu and what to pick from the right side of the menu.
Thank you, Chris. Thank you for that. Terri, this question is very specifically for you, and the participant asks, Terri, were your values, and I'm assuming it's health related or health disparity related or health equity related values, were they challenged in the course of proposing environmental justice regulations for the expansion area?
Another good question. Were my values challenged? Yes. But I would say it was such a welcome area of focus for me as a planner interested in, the public good and advancing equity and those sorts of things, to have direction specifically from our council to study this issue, when more commonly what you hear is this neighborhood wants to stop negative impacts from infill or those kinds of things. That's typically what gets lobbied up through our city council for planners to focus on. So this was a new direction and a new project that I personally embraced as being very in line with my values. So I'm happy to say that I didn't ever feel like I was in a position where I was compromising my values in working on this. However, there were a lot of discussions where different priorities had to be balanced, and that came up earlier with the question about economic development. So that very much has been part of the discussion. How do you prioritize or balance environmental justice sorts of perspectives when you're also trying to meet economic development goals? And I've found myself saying over and over again that we take our direction to focus on environmental justice seriously, and where there was a question, we erred on the side of that issue.
That's good, Terri. Thank you for that. Thank you very much. I've got a question here for Chris, and participants, those of those that still on the line, please go ahead and continue adding your questions to the chat box. But Chris, it said you mentioned quite a few policy interventions that seem to clearly work in urban and maybe even suburban settings. But will these policy interventions work equally in rural settings? What's the application in that sort of setting that you think?
That's also an excellent question. What we have found is the basic underpinnings are the same, that the combination of policy and environmental and transportation interventions will improve people's access to healthy food and physical activity. But the nature of them will be different between LA and New York versus Sheboygan and Des Moines. If you live in a rural area, for instance, Jackson Hole, Wyoming comes to mind, you can create a network of active transportation and active living pathways for walking, hiking, and bicycling, as well as potentially transit from the outlying rural villages into town, because everybody has to periodically go into town if you live in a rural area to purchase things, to see friends, to go to the movies or whatever. And the idea is to make it possible for people to go into town and walk around in town versus drive around in town. If everybody can picture Andy Griffith and Mayberry, everybody walked around a lot. The issue is, if we, in a rural setting, it's the same as in an urban or suburban setting. If we incentivize, consciously or unconsciously, moving around in our cars by how we place parking and whether or not there's sidewalks and those kinds of pedestrian amenities, will either encourage people to be more physically active or discourage them. But again, it comes down to the local experts are going to know what's likely to serve the local population and support that active and healthy lifestyle, whether it's eating or physical activity, the best. It's just a matter of taking the higher order science and applying it to your local circumstance.
That makes sense, Chris, to really sort of customize it to the needs of the community. Look at it and work. That's helpful. This next question is for you, Melinda, and I'm going to go ahead and offer the disclaimer that that if you do decide to take on answering this question, you are not providing legal advice, just some education. It says, we've received a request to install a crosswalk at a T intersection. If installed, we would build an ADA ramp on one side of the street, but the other side of the street does not have a sidewalk and would essentially put the user in the middle of a street. Is there a legal issue that we should worry about if we build a crosswalk that leads people into the middle of the street? And since there's an ADA component, Chris, if you have thoughts on that, please feel free to chime in.
Yeah, I would caution the person asking the question to certainly talk to their legal department, because it might also be state specific. But if my department was asking me that question here, I think some of the legal concerns that I would have is kind of really based on the intersection itself. Is the ADA ramp and crosswalk that's being put in, if it's creating more of a hazard than a help, then perhaps it shouldn't be put in. Certainly you don't want to put people in a more dangerous situation that originally exists in that. I think if the ADA crosswalk on the one side of the street, there's no real issue with that, and the question was really referencing the other side of the street, which doesn't have a sidewalk. I think so long as you provide a pathway to get to the side of the street that has a crosswalk on it that's available, that should be good. But of course, I mean, if you talk to any attorney, we're going to be concerned with the city's liability if we're creating a more dangerous situation. So certainly I would encourage you to talk to your legal counsel.
This is Chris. I agree with that completely. What I would say is that when you're dealing with populations that have particular needs, whether they're children, older adults, or persons with disability, the whole idea is to understand their needs, the most consistent and likely needs, and to serve those. So having something like that circumstance probably may not be the best solution. I've seen places where there is an accessible bus stop pad, but you can't get off the pad. You can get off the bus onto the pad, but then you cannot get off the pad to go anywhere. And that seems like a perfect example of where somebody was following the letter of the law without actually looking at the larger context of why the rule or code was in place and what the subpopulation that it's supposed to serve really needs.
Very helpful. Thank you, Melinda and Chris, for that. This next question is for Terri. And Terri, it's about this process of building trust. Really, can you talk to us a little bit more about what that looked like? Did any of this work take place prior to the official launch of Envision Eugene?
Great. It was the official launch of Envision Eugene, and the community resource group was a part of it, but it was really an approach based on the work of a guy named Robert Chadwick. And our city manager had worked with Bob in a previous job, and he brought Bob to Eugene to do a series of interviews, listening interviews, with stakeholders that were very diverse, from, you know, people who were part of logging families that were kind of old Eugene money, to folks who were associated with the environmental movement, because that is one of the deepest divides in Eugene, is between environmental and development interests. So Bob Chadwick was very influential into our thinking around this. Sadly, he passed away a couple of years ago, but before he did, he published a book called Finding New Ground. You can find that on Amazon. And we really did fully embrace his method of listening circles and balancing power and matching men and women, and just a whole bunch of techniques for building consensus and resolving conflict in community.
And what was the name of that book again, Terri?
It's Finding New Ground, Robert Chadwick.
Finding New Ground, Robert Chadwick. Okay, thank you for that. And one other sort of piggyback question on that for you is, in Eugene, was there a single backbone agency or organization responsible for championing or advancing the public health / environmental justice approach across the agencies? Was there one sort of central champion?
Well, the champion was definitely Beyond Toxics, the local organization, but it's one of those issues where it's sort of like, okay, whose job is it to advance this? And luckily, we have a very collaborative relationship with our local county health department, Lane County, and so they were very much a part of the discussion, as well as our air quality regulating agency. For example, Lane County offered to facilitate any health impact assessments that needed to be done as new companies look to locate in this new area, and we're looking at environmental justice regulations if they were unfamiliar. So it's pretty collaborative, but as far as a champion, I would say it was Beyond Toxics, and they were the ones to bring it to the attention of the city councilors, and that's how it resulted in a work plan item for us.
Excellent, thank you. And I'm not really sure who can take this question on, so I'll ask it, and you guys kind of let me know what you think. How would you answer a question from a developer with regard to a return on investment from the requirement or mandate of building sidewalks and bike lanes on complete streets?
This is Chris. I'll take a first stab if that's okay. The first thing that we found is that oftentimes many players in these kinds of processes believe that there won't be a positive return on investment when in fact there is evidence to the contrary, whether they be business owners or developers. Many of the residential developers and realtors are starting to include walk score on their marketing for housing and commercial development, because so many people indicate that they want to be in walkable areas. So there may be positive return on investment at the far end, but in the middle part, what we've also discovered is that many developers are willing to work with the planning department, the transportation department, or the public health department to make changes to requirements. One example that I was told years ago was that if a developer could speed up the development review process so that they didn't have to maintain a mortgage on a large piece of property for as many months as they normally would, that they would be willing to consider a road diet and to changing and adding to the pedestrian infrastructure and amenities that they were planning, and that it would be a net gain for everybody because the community that was built would be different than it was planned to be, but it would be able to be built and turned over and sold faster than was originally proposed. So I think approaching all of the players in a collaborative fashion and looking for ways to support each other's efforts through things like expedited development review can really assuage some of the concerns that may be there.
That's really good, Chris. Thank you. Melinda, Terri, thoughts on how we can talk about this idea of return on investment with developers?
I think what we've experienced here in Fort Worth, and I think certainly as we're making this generational transition from boomers to millennials, I think millennials, when they're buying property, they have an expectation that they're going to be able to recreate on that property, either through walking or biking or other thing. It's just kind of a given for them. So I think developers who are forward-thinking and include that kind of ability to do that into their communities, whether they're building a commercial or a mixed-use kind of development, or they're in the suburban areas and they're building a master plan community, if they provide that, I think that's more attractive to millennials as they get older and are able to buy homes, and to, quite frankly, to other generations, baby boomers, Gen Xers, as we all transition to try to get out there and become more healthy, as we see that kind of societal, not pressure, but encouragement, that I think people are starting to actively look for places like those. So I think the market kind of drives it, and that's their return of investment for it.
I would agree. I think the market is starting to catch up with what we've been planning for and encouraging our development community to kind of shift what they're willing to invest in and build. I would also say once developers know what the requirements are, and those requirements have been upheld as legal through our state acknowledgement process, then they're happy to comply with them. It's the uncertainty of neighborhood opposition or appeals that really drives them crazy. But if they have a requirement and it's predictable and they know what it is, what they're required to provide, we don't run into a lot of resistance.
This is Chris. The one other thing that occurs to me I could throw in here is that a lot of times people resist some of these things because of a perception based on how they understand the language. We've often found that if you show people pictures of the type of development that you're talking about, they very much resonate with it. But if you use words like density and those kinds of things, they have a predetermined perspective on that, and apparently it's some type of Greenwich Village type development that they don't want. So again, the most important thing with individual citizens, citizen groups, or developers, I think, is to make sure that everybody is on the same page.
Thank you. Thank you to all of you guys for taking that question on. I'm going to ask this last final question. We've got such good questions in the box, so this will be our last one. And I think, Melinda, we'll start with you on this one. And it's, can you comment on the June 24th Supreme Court decision in the Murr case, where a court decided that the government does not have to provide compensation for certain taking? Any thoughts on that?
I haven't had a chance to fully read it, but I am encouraged by them finding that merger occurs in a lot of communities that then would kick in whether or not a regulatory take is there. So I find it encouraging that they didn't find that there was a regulatory take for this particular back situation, and that they went ahead and went through all of the takings analysis that they've previously established since then. I think that's the right kind of, from my perspective as a municipal attorney, I think that's kind of the right way to go. The only thing that I would like a cautionary tale to put out there for other states like Texas that are very heavy property rights states is that when your legislature doesn't like a decision that the federal Supreme Court has made, they may go and change their laws to kind of address that. So sorry to take up too much time, but Kelo decision was a perfect example where economic development fell under what you could do as part of happening, and then Texas went and basically made it very difficult to do any economic development acquisition and made any kind of thing like that a take. So while I'm encouraged, I just hope states don't overreact to that in trying to bolster property rights.
You know, thank you for that, Melinda. Jenny, I know you were on the line. Did you have any thoughts that you wanted to add to Melinda's response in your role as a lawyer as well?
Sure. And since we have so many people on the call, if I'll just take 25 seconds to just give a little background for people who don't know that this case, the Murphy, Wisconsin regulatory takings case, it dealt with the validity of a lot merger provision, the impact of local environmental regulations, the extent of the parcel as a whole rule. There were sort of all these factors playing in, but really the Supreme Court's issue that they were dealing with and their holding was limited to really weighing in on how to determine the relevant parcel for a takings analysis. That's what this was really about, because there were two lots this family owned that were next to each other, and there was a merger provision in the local zoning, and there were also some local environmental regulations within the zoning that were restricting the use of the developable acreage of the lot. And so the whole point of this was that the property owners, if you looked at the lots separately, and you looked at the developable area of one of the lots, lot E in this instance, the developable area was so limited. It was not, you couldn't develop the lot under the local ordinance, and so it would have been a Lucas-style total taking analysis, whereas if you looked at the merger provision and looked at the lots together, there was some economic value left, and you would go to the Penn Central multi-factor balancing test. That was sort of the issue. And so the Supreme Court did uphold the merger provision and said that there were a number, but they created another multi-factor test looking at the treatment of the land under state and local law, the physical characteristics of the land, the prospective value of the regulated land, so looking at the potentially positive impact that the restriction on one of the lots might have on the value of the adjacent lot, and looking at those standards to determine whether the reasonable expectations about property ownership would lead a landowner to anticipate that the holdings would be treated as one parcel or instead as separate tracts. And in doing so, they upheld the lower court's determination that the two lots should be evaluated as merged, as combined. So it's not a huge departure from parcel as a whole norm. The relevance of this to the topic of today, I think, is in terms of the significance that was placed on the environment in some of the court's commentary. And so that's, looking at the nature of the surrounding environment and the property is something that the court has stated clearly is relevant in that determination.
Thank you for that, Jenny. Thank you. All right, folks, we've gone over on time, but I want to just leave the last at least 60 seconds for Anna or Jenny to make a plug for membership in the planning division, and just say thank you once again for joining us on this very educational webinar. Annie, yes, Jenny, anybody want to close out?
I can close out. This is Anna. I'm really happy to see so many people on the line. We had over 400 people today, and the recording will be available in about a week, so people can rewatch it. And I really appreciate the attention that this topic is getting. Have a great afternoon.
Thanks, everybody. Bye.